Welcome back to this course on copyright and related rights law. In the previous session, we had discussed what the right to receive royalty is. We had seen it in context to authors of literary and musical works. These authors had long demanded that certain practices that were being followed in the industry, because the recognition of first ownership of producers with respect to their works was prejudicial to their interest. Accordingly, as a solution, the 2012 amendment to the Indian Copyright Act had introduced the right to receive royalty under Section 18, which deals with assignment. This curious inclusion within this provision raised a question as to whether this can be considered as a substantive right without it being included within Section 14 that looks to define what copyright is. We had seen how it can in fact be considered as a substantive right. Moving forward, in this particular session, we are going to see how right to receive royalties can be extended to performers for their performances. Let us recall what we had discussed in our earlier discussion with respect to economic rights of performers. I am referring to Section 38A of the Indian Copyright Act, which provides for performers' rights. Under this particular provision, let us consider Clause 2 and what it says with respect to a producer enjoying performers' rights. As you can see, this provision reads that once a performer has, by written agreement, consented to the incorporation of his performance in a cinematograph film, he shall not, in the absence of any contract to the contrary, object to the enjoyment by the producer of the film of the performer's right in the same film. This means that the producer will enjoy the performer's right where the performance is incorporated in the film. In continuation, this provision then states, provided that notwithstanding anything contained in this subsection, the performer shall be entitled for royalties in case of making of the performances for commercial use. We had understood that commercial use has been interpreted within Rule 68 of the Copyright Rules 2013. Under Rule 68, Explanation 2 explains that commercial use as mentioned in proviso to subsection 2 of section 38A means the exploitation of performers' right by way of reproduction, issue of copies or distribution, communication to public including broadcasting, and commercial rental of the cinematograph films. What we are understanding is that under this provision, under the main provision, it is said that the producer will enjoy performer's right where the performer has consented to the incorporation of the performance in the film by way of written agreement, but despite the producer enjoying such performers' right, the performer will be entitled to royalties. Royalties would be a certain share from the amount that is being collected by the producer with respect to certain kinds of usage of such performance. Let us then understand whether This is a right of the performer, which we can call as a right to royalty, and whether this right to royalty is something which is unassignable or unwaivable. Because if the producer who realizes that there is a provision within section 38A which places a limitation on the exercise of the commercial utilization of the performances incorporated within the film, then wouldn't the producer get this right waived or get it assigned in his favor? And is that something which is possible? Let us consider this case that arose before the Madras High Court. This case is Veeramani Kannan versus Super Audio Madras Private Limited. Let us see a clause within the agreement between Veeramani Kannan, who is the singer or the performer, as well as the composer and the author, along with the record label. In this particular agreement, you can see clause 3.3, which states, further and without prejudice to the above assignment and in consideration of this agreement, in regard to any audiovisual recording and or sound recording of any performance made by assigner in pursuance of this agreement, the assigner releases, relinquishes, transfers and assigns all its rights to royalty under section 38A clause 2 absolutely to the producer in exchange for a lump sum royalty payment as mentioned under this agreement in clause 4. The assigner, you would note, is the performer. What does this provision say? It states that the performer is willingly relinquishing, meaning that he is not looking to claim his right to royalty and is also assigning it away. In the sense, the right which is prevailing under 38A clause 2 is being given to the producer. Therefore, what limitation 38A clause 2 proviso would have had on the producer's commercial utilization, and in turn meaning a royalty right or consideration which should have gone to the performer, has now been discarded. So the question that the court considered whether this particular right can in fact be assigned away. What the judge had said is that having relinquished and transferred his right to royalty under section 38A clause 2, specifically on the receipt of a lump sum payment, the plaintiff cannot seek for relief of royalty under this section. Section 38 and section 38A are the provisions which confers special right exclusively upon the performer to claim royalty when the performance is commercially used. However, by contract, if the performer relinquishes the said right on receiving a lump sum consideration, thereafter he cannot enforce the right conferred under the proviso to section 38A clause 2. For the judge, in consideration of this particular provision, there is nothing to indicate that this right can in fact not be assigned away. You can see for yourself. This proviso simply says that a right to royalty shall arise in the name of the performer. But it does not say anything about whether such a right can in fact be relinquished or can it be given away. This is not stated, and therefore, in having given it away in exchange for a payment which supposedly includes the royalty as well, then in such a scenario, no further claim can arise on account of 38A clause 2. What's important here, you will see, is that the lump sum consideration was a mere 19,900 rupees. This brings to our minds, surely, a question, which is that this treatment that is being meted out to performers is something that we have seen earlier. We have seen such a treatment being meted out to authors of literary and musical works, haven't we? Is this not a sign of an unfair treatment being meted out to performers, where a due consideration for their creative expression, even though provided for within the Act, has been forced to be given away? And now that the performer is asking for the right to be enforced, it is being stated that it was willingly given away. We had seen, in response to the demands that were being placed by authors of literary and musical works against the unfair treatment that they were receiving from producers of cinematograph films, what was stated by the standing committee was that the committee takes note of the fact that independent rights of authors of literary and musical works in cinematograph films are being wrongfully exploited by the producers and music companies by virtue of the Supreme Court judgment in this particular case, which held that film producer is the first owner of the copyright and authors and music composers do not have separate right. In the case of authors, the Supreme Court decision in 1977 had used Section 17 provisions to provide first ownership to producers with respect to underlying work copyrights. With respect to performers' rights, 38A clause 2 is very clear that once performances are incorporated within cinematograph films through a written agreement, then unless there is anything in that agreement, the producer will enjoy all performers' rights. Can we say that a similar issue has arisen with authors, can arise with performers as well? If yes, how can this issue be resolved? Can we apply a similar solution as we had seen being applied with respect to authors, wherein a right to receive royalty was introduced within the Copyright Act for authors? Can such a right also be introduced for performers? The concern that we would see is that in Section 18, in which the right to receive royalties has been introduced, it specifically in its terminology refers to authors of literary and musical works. So even if the right to receive royalties has to be extended to performers, it must be done in such a way that this provision is either modified or a separate provision which talks about the right to receive royalties for performers is included within the Copyright Act. It is the first option that we see has been followed with respect to the Copyright Act. Section 39A, which talks about certain provisions which would apply to performers' rights upon necessary modifications and adaptations, talks about Section 18 being the subject of such a necessary adaptation and modification. which means that now the provision that was inserted specifically for authors of literary and musical works can now be read as talking about performers' rights and performances. In line with this understanding, I have modified the said provisos which talk about right to receive royalty under section 18 in including performers' rights and performances. And this is how the provisos would read. It would say, provided also that the performer of the performance included in a cinematograph film shall not assign or waive the right to receive royalties to be shared on an equal basis with the assignee of performance for the utilization of such performance in any form other than for the communication to the public of the work along with the cinematograph film in a cinema hall, except to the legal heirs of the performer or to a performer society for collection and distribution, and any agreement to contrary shall be void. Provided also that the performer of the performance included in a sound recording but not forming part of a cinematograph film shall not assign or waive the right to receive royalties to be shared on an equal basis with the assignee of performance for any utilization of such performance except to the legal heirs of the performer or to a collecting society for collection and distribution, and any assignment to the contrary shall be void. Upon this modification, what we see is that similar to the application of right to receive royalties with respect to authors whose works were incorporated in cinematograph films or sound recordings, we can now consider performances as included within cinematograph films or sound recordings which are not part of cinematograph films. What is beneficial for performers is that unlike section 38A clause 2 proviso, which talks about a right to royalty but does not talk about whether such a right can be assigned or not, under section 18, these provisos very clearly say that the right to receive royalty cannot be assigned nor can it be waived. And therefore, this is a mandatory form of royalty which will arise to performers despite there being some kind of a relinquishment or assignment of the right contained under 38A clause 2. Please understand. When we took a look at this case, we saw that the performer had, through agreement, relinquished and transferred and assigned the right contained under 38A clause 2 proviso, which is the right to royalty. Even if such a assignment agreement is in force, even then the right to receive royalties will still be applicable. In a matter that arose before the Delhi High Court in 2016, this is ISRA versus Chapter 25 Bar and Restaurant. ISRA, or the Indian Singers' Rights Association, is a performers' society. It stated that Section 39A Clause 1 of the Act, inter alia, states that Section 18 shall, with necessary adaptations and modifications, apply in relation to the reproduction right in any broadcast and the performer's right in any performance as they apply in relation to copyright in a work. Therefore, the court is following the line of reasoning which we had understood, in which the court is first focused on whether the right to receive royalties can be made applicable to performers' right in the first place or not. And how will it see that? By seeing whether the right which is included within Section 18 is in fact applying to performances. And just like we had seen, that Section 39A, Clause 1, extends with necessary adaptations and modifications Section 18 to performances. And therefore, the court says that the plaintiff has been able to prove the infringement by the defendant of the right to receive royalty of the members of the plaintiff society in the performances as recorded in the CDs prepared by the plaintiff's investigator. The playing of songs by the defendant in its restaurant without payment of royalty to the plaintiff is a violation of the right to receive royalties of the performers who are members of the plaintiff. Therefore, we can see that the Delhi High Court has used Section 39A in applying right to receive royalties to performers' rights and performances, and therefore has stated that where Section 18 would then apply and sound recordings have been played in an establishment without the payment of royalty to performers, it will be considered as a violation of the right to receive royalties of performers. Let us now consider the question of how right to receive royalties for performers will be calculated. In a similar line of understanding as we had taken in the previous session, because there is no course of assessment that has been charted out objectively within the Copyright Act, all that it says under Section 18 is that sharing must be on an equal basis, which makes us understand that on an equitable consideration of what is a fair share for the contribution of that performance in that particular sound recording or that film, such a royalty must arise. Eventually, what this means is that the right to receive royalty calculation is an industry assessment. In rounding up this consideration of right to receive royalties, and specifically with respect to performers, we must keep in mind, as was the case that came before the Madras High Court with respect to this performer, Veeramani Kannan, that contractual practices in the industry can be such as to take away all rights that are existing within the Copyright Act. It is then the onus on the performer to be vigilant to ensure that certain rights, such as the right to receive royalty, which are unwaivable, even if there is a provision within that agreement which says that the performer will not lay a claim on any right to receive royalty, you should understand that such a provision will be invalid and the right to receive royalties will subsist. In the next session, we will take a look at the importance of registration, publication, and term connected to copyright, followed by term connected to performers and broadcasting. Thank you for joining me. See you all in the next session. Thank you.